Most electricians in North Carolina treat a missed permit as a problem between them and the inspector. You pay the double fee, you pull it late, pass inspection, and then you just move on. There's a rule in the North Carolina Administrative Code, though, and that's 21 NCAC 18B.0909, that says failing to get the permit before you start the work is evidence of malpractice, gross incompetence, or gross misconduct. Not a code violation, not a fee, evidence, the kind the State Board of Examiners of Electrical Contractors can act on. And under North Carolina General Statute 87-47, one of the penalties available to that board is suspending your license for up to 12 months. That's 1 year. On a job where the wiring was fine and no one got hurt. That gap between how the field sees permits and how the board sees them is what I want to close. My name is Nick Dogle. I'm an attorney and the owner of North State Law here in Raleigh, North Carolina, and my practice is professional license defense. If you hold a limited, intermediate, or unlimited license in this state, or your name sits on someone else's license as the qualified individual, this video is for you. I'm not here to tell you the board is out to get you. In my experience, though, it isn't. What I am here to tell you is that the board evaluates permits very differently than a job site does. And let me show you where. Article 4 of the North Carolina General Statutes under Chapter 87 exists to protect the life, health, and property of the public. But the board has no inspectors on your job site. It can't check your terminations. The permit and inspection system is the only mechanism the state has to verify that licensed work was done to code. So when a permit gets skipped from the board seat, that isn't a paperwork issue. That's the failure of the one thing standing behind the license. Second piece most contractors miss is under General Statute 87-46, and it says nothing in the licensing article relieves a license holder from complying with the building and electrical codes or local ordinances. Code compliance is written into the license itself. And under 87-47, any person may prefer charges to the board in writing. Homeowner, a GC, a competitor, an inspector. Board staff can initiate charges on their own as well. Let's look at Rule .0909. It carries a title that tells you where you should stand before you read a word of it, and that's, quote, malpractice further defined. Subsection A says a licensee shall ensure that a permit is obtained from the local code enforcement official before commencing any work for which a license is required, and shall request final inspection within 10 days of completing it. Read that verb, ensure. Not apply for, not assume the GC handled it, ensure. Subsection C is what changes the stakes. It says failure to comply with those permit and inspection obligations is considered by the board as evidence of malpractice, gross incompetence, or gross misconduct. Those three phases come straight out of 87-47 subsection A1 subsection 7, the list of prohibited activities, which means a permit gap doesn't have to be argued into a disciplinary theory. The board's own rule already put it there. And separately, under General Statute 160D-1110, starting that work without the permit is a Class 1 misdemeanor. Let me make that concrete. Let's say Marcus holds an unlimited license and runs a four-man shop. A builder he's worked with for 9 years calls on a Thursday. Can you roughen the townhouse over the weekend? The builder says he'll pull the permit on Monday. Marcus roughs it in. Clean work. Monday, the permit gets pulled. The inspector arrives, sees rough-in already complete under permit issued that morning, and asks one question. When was this done? Nothing collapsed, nobody was hurt, the wiring passes. But there is now a written record with the date on it. The inspector may report it. Local code officials work alongside this board constantly. And under 87-47 subsection A4, that report becomes a charge in writing. Then the file gets built. Board staff can request contracts, invoices, job logs, permit histories, and one date discrepancy is a much smaller problem than a pattern, which is what a records request surfaces. That's the path, not a catastrophe, but a paper trail. Now, this is where most professionals get into trouble. It is almost never the permit that does the damage. It's the 2 weeks or so after. You gotta be careful and not over-explain. So let's say a contractor gets a letter from the board and writes back 4 pages covering every job he ran that month, trying to show good faith there. He's handed the board information about jobs it never even asked about though. Another issue I've seen is fixing records after notice. They're adjusting an invoice date, asking a builder to resend a text. A permit issue sits under 8747 subsections A1 under 7, malpractice or misconduct. Altering a record after notice can pull it into subsection A1, subsection 5, fraud or misrepresentation in electrical contracting. So you've traded a compliance problem for a dishonesty problem. Those are not weighed the same way. And let's look at treating the board casually, because that happens sometimes. You get a notice from a licensing board. It's not a customer service inquiry. You generally have 20 days to respond in writing. And that response is often the most important document in the file. So you got to be careful how you delegate without oversight as well. And that's the most underappreciated of all of what I'm saying. Your license doesn't travel with your hands. It travels with your supervision. So checking out General Statute 87-41.4, that gives the listed qualified individual the duty and authority to supervise and direct electrical contracting done in the licensee's name. And if we look back at Rule .0907, that defines supervision as active on-site review while the work is in progress. And where a firm employs more than one qualified individual, Rule .908 makes each responsible for the work of the firm. So each qualified individual is responsible for the work in the firm under that rule. So when a foreman decides to start on a Saturday without the permit, that decision reaches your license. There's a related trap here. Rule .0909 subsection B says a licensed contractor shall not allow a permit to be obtained or his license number to appear on a permit except for work he or his employees actually perform and supervise under contract. So the common workaround here is letting the homeowner pull it or letting your number sit on a permit covering someone else's crew. That's its own separate violation. And it doesn't solve the first problem, it adds a second problem on top of the first. Speaking generally, here's what we often see working. Treat the permit as a start condition, not a schedule item. In many cases, the shops that stay out of trouble run one rule: no permit number, no truck. That's a mindset, and it survives a Thursday phone call in a way good intentions don't. Document who's responsible for pulling the permit. When the GC is handling the permit, put it in the contract and confirm it in writing. That doesn't erase the insurer obligation in .0909, but it changes what your file looks like. And generally speaking, if a notice does arrive, the most valuable thing you can do first is nothing. Don't respond that afternoon. Don't call the complainant. Don't touch the records. Read it, note the deadline, and decide deliberately on what you're going to do next. So a skipped permit is not a fee problem. It's a licensing problem. The board's own rule defines it as evidence of malpractice, gross incompetence, or gross misconduct. And the penalties under North Carolina General Statute 87-47 run from a reprimand to suspension for up to 12 months to revocation. So the work being good is not the defense. The work being verifiable is. This doesn't mean the board is unfair. It means the board is documentary. And documents get written before you know anyone's reading them. One last thing, and I want to be direct about it. If a notice of violation from the electrical board ever lands in your mailbox, there's a window before you write anything back where you hold more control over that file than you ever will again. 20 days sounds like plenty of time, but it isn't, because most people spend 19 of them writing the wrong letter. So here's the one thing I'd ask you to take from this video. Talk to a licensed defense attorney before you respond to the board, not after, before. That decision shapes the record everything else gets measured against, and making it early costs you nothing. Our firm is North State Law, and defending professional license is all that we do. Please subscribe if this was useful. I break down one enforcement risk at a time. Thank you so much for watching. Keep the lights on in North Carolina. Bye-bye.